Imagine standing in the immigration line at a major U.S. international airport like JFK, LAX, or O'Hare, exhausted after a long flight from overseas, clutching your passport and your green card, expecting the usual routine of a quick scan and a welcome home. But instead, the Customs and Border Protection officer swipes your card, pauses, looks at his screen with a furrowed brow, and then picks up his phone to call for backup, leaving you standing there with your heart pounding in your chest as two uniformed officers approach to escort you to a secondary inspection room where you are stripped of your phone, cut off from your family waiting outside, and told that the U.S. government believes you have abandoned your permanent resident status. This is not a hypothetical nightmare scenario or a scene from a movie. This is a harsh, unfolding reality for thousands of lawful permanent residents right now, as the Department of Homeland Security has quietly but aggressively ramped up enforcement at ports of entry, targeting green card holders who spend significant amounts of time abroad. And if you are not fully aware of these new enforcement policies and the specific legal traps being set for you, your next international trip could end with you being denied entry, stripped of your residency, and placed in removal proceedings. Welcome back to U.S. Immigration Insight, your premier, most detailed, and most trusted source for navigating the labyrinth of the U.S. immigration system, where today we are going to conduct a comprehensive, deep-dive forensic analysis of exactly why DHS is blocking certain green card holders from re-entering, why this enforcement is spiking specifically in 2026, the legal mechanics of abandonment of status, and the specific step-by-step defensive actions you must take immediately to protect your future in America. This is arguably the most critical update for anyone who holds a green card, whether you are a conditional resident who received your card last month or a 10-year resident who feels secure because the rules of engagement have changed, and ignorance of these specific legal nuances is the primary reason people are losing their American dream at the border. To understand the gravity of the situation, we must first dismantle a common myth that many immigrants believe, which is that a green card is permanent in the absolute sense. But the reality is that your status is a privilege, not a right, and it is conditional upon you maintaining the United States as your primary, actual, and permanent domicile. The Department of Homeland Security and Customs and Border Protection are currently utilizing sophisticated travel tracking databases and algorithmic flagging systems to identify what they call perpetual tourists, which are green card holders who treat their residency as a convenient travel visa or an insurance policy rather than a real home, living the majority of their lives abroad while returning to the U.S. for short visits once or twice a year, just to keep the card alive. In the past, officers might have let this slide with a stern warning, but in the current enforcement climate, officers have been instructed to apply the full weight of the Immigration and Nationality Act, specifically focusing on the legal concept of abandonment, which is not just about how much time you spend outside the country, but about your intent, your behavior, and the center of gravity of your life. When you are pulled into that secondary inspection room, you are entering a legal battlefield where the burden of proof shifts onto you to demonstrate that your trip abroad was temporary in nature and that you never intended to sever your ties with the United States. The interrogation you will face in secondary inspection is designed to be grueling, repetitive, and psychologically pressured, intended to catch you in a lie or force you to admit that your real life is elsewhere. The officers will not just ask, "How was your trip?" but will launch a granular investigation into the minutiae of your existence, asking specific questions like exactly where you sleep when you are in the U.S., and if you provide the address of a relative or a friend. They will check databases to see if your name is on the utility bills, the lease, or the deed, and if it isn't, they will use that as evidence that you are merely a guest in the U.S., not a resident. They will interrogate you about your employment with extreme prejudice, because if you are working a full-time job in a foreign country, receiving a salary in a foreign currency, and paying foreign taxes, DHS views this as definitive proof that your principal place of business and therefore your life is abroad, regardless of whether you own a house in Florida or have a bank account in New York. They will ask about your family connections, demanding to know where your spouse works and where your children go to school. Because if your immediate family lives abroad while you claim to live here, the presumption is that your heart and your home are with them, not in the U.S. Perhaps most critically, they will demand to see proof that you have filed U.S. federal income taxes as a resident, because many green card holders mistakenly believe that if they earn money abroad, they don't have to file U.S. taxes. But under U.S. tax law, as a permanent resident, you are taxed on your worldwide income, and failing to file a Form 1040 or filing as a non-resident is often cited by immigration judges as the ultimate objective proof that you abandoned your status. This crackdown is affecting specific demographics of green card holders more severely than others, and you need to know if you fall into one of these high-risk categories. The first group is the employment-based professional, individuals who worked hard to get an EB-1, EB-2, or EB-3 green card, but then were transferred by their company to an overseas branch or decided to take a lucrative job back in their home country, thinking they could commute or manage the business remotely. DHS is now flagging these individuals aggressively because their economic center of gravity has shifted. The second vulnerable group includes elderly parents, often those who were petitioned by their U.S. citizen children but found the winters too cold or the culture too isolating. So they spend 10 or 11 months a year in their home country and only visit the U.S. for a few weeks to see the grandkids and renew their status. Officers are now telling these seniors that they are essentially visitors, not residents, and should surrender their green cards. The third group is the accidental expat, people who went abroad for a temporary purpose, like caring for a sick parent or studying for a degree, but allowed that temporary trip to stretch into 2, 3, or 4 years without obtaining the proper permits, and now find themselves unable to prove that their absence was truly temporary. The most dangerous weapon in the CBP officer's arsenal during these encounters is Form Y-407, officially known as the Record of Abandonment of Lawful Permanent Resident Status, a document that officers will often present to exhausted, terrified, and jet-lagged travelers as a simple solution to their problem. The officer might use psychological tactics, saying things like, "Look, it's clear you don't really live here, and if you try to fight this, we will detain you, put you in jail, and ban you for years. But if you just sign this form, you can enter today as a tourist, visit your family, and go home with no trouble." This is a coercive trap because if you sign Form I-407, you are voluntarily and legally surrendering your green card, an action that is almost impossible to reverse later in court because the government will argue you did it of your own free will. If you find yourself in this situation, you must understand your rights. You have the absolute right to refuse to sign Form I-407, and if you refuse, the officer cannot force you to surrender your status on the spot. Instead, they must issue you a Notice to Appear, NTA, and refer your case to an immigration judge. While the prospect of facing a judge is terrifying, it is infinitely better than signing away your rights because it allows you to enter the country, hire an attorney, and present evidence to a judge who, unlike the border officer, must weigh the totality of the circumstances and give you due process. Now that we understand the threat, we must discuss the legal framework of admission versus returning resident, because this is the technicality that trips everyone up. Under the Immigration and Nationality Act, if you have been outside the U.S. for less than 180 days, approximately 6 months, you are generally not considered to be seeking admission, meaning the burden is very high for the government to stop you. However, once you cross that 180-day mark, and certainly once you cross the 1-year mark, the legal presumption shifts, and you are treated almost like a new applicant trying to enter the U.S. for the first time, subject to all grounds of inadmissibility including health, criminal, and public charge grounds. This is why the 6-month rule is so often cited by lawyers. Staying out for more than 6 months doesn't automatically kill your green card, but it opens the door for CBP to ask questions, while staying out for more than a year creates a legal presumption that you have abandoned your residency unless you have a valid re-entry permit. This brings us to the most critical preventative measure you can take: the re-entry permit, Form I-131. If you know that you need to be outside the United States for more than 1 year, but less than 2 years, perhaps to finish a degree, care for a dying relative, or work on a specific project, you absolutely must apply for a re-entry permit before you leave U.S. soil. You cannot apply for this document from an embassy, you must be physically present in the U.S. when you file, and you must stay until you complete your biometrics, fingerprinting, appointment. A re-entry permit serves as a legal presumption that you intend to return, effectively telling the government, "I am leaving, but I am not abandoning my home." However, do not fall into the trap of thinking a re-entry permit is a get-out-of-jail-free card. Even with a valid permit, you can still lose your residency if you take actions that signal abandonment, such as claiming to be a non-resident on your tax returns or selling your only U.S. home. It is a shield, but it is not impenetrable, and you must still maintain your ties to the U.S. while you are gone. But what if you are already abroad, you have been gone for more than a year, and you did not get a re-entry permit? You are in the danger zone, and simply showing up at the airport is a gamble that could cost you everything. In this scenario, your correct legal path is to apply for an SB1 returning resident visa at the nearest U.S. consulate, a process that requires you to prove that your extended absence was caused by forces completely beyond your control, such as a medical incapacitation, a global pandemic lockdown, or a war, and that you never intended to abandon your status. I must be honest with you, SB1 visas are notoriously difficult to get, with denial rates in some consulates exceeding 80% or 90%, because the consular officers have strict instructions to deny anyone who simply chose to stay away. If your SB1 is denied, or if you choose to bypass that process and fly to the U.S. anyway, you must be prepared for a confrontation at the border, and you should carry a binder of proof with you in your carry-on luggage. This binder of proof is your ultimate defense weapon, and every green card holder who travels frequently should have one. It should contain certified copies of your last 3 years of U.S. federal tax returns, Form 1040, proving you filed as a resident. It should contain proof of your U.S. domicile, such as a deed to your house, a lease agreement, or property tax payments. It should contain evidence of your financial life in America, including active bank account statements, credit card bills showing local transactions, car insurance policies, and health insurance coverage. If you have children, include their U.S. school report cards. If you have a job, include a letter from your employer stating that your absence was for a specific temporary assignment and that your job awaits you. The goal is to overwhelm the CBP officer with objective evidence that your life is anchored in the United States, making it difficult for them to argue that you are a visitor. We also need to discuss the intersection of tax law and immigration law, because this is a hidden landmine that destroys many residents. The IRS and DHS share data more freely than ever before. If you have significant assets and you lose your green card, either by signing Form I-407 or by a judge's order, you could be subject to the expatriation tax, often called the exit tax. This applies if you have been a permanent resident for 8 of the last 15 tax years and you meet certain income or net worth thresholds, generally a net worth over $2 million. In this scenario, the IRS treats you as if you sold all your worldwide assets on the day you lost your green card and sends you a bill for the capital gains tax. This means that casually signing Form I-407 at the airport to avoid a hassle could trigger a tax bill for tens or hundreds of thousands of dollars. This is why I tell my viewers, never, ever sign legal documents at the airport without speaking to a lawyer, because the consequences ripple far beyond just your ability to board a plane. Let's look at a specific case study to illustrate how these rules apply in real life. Imagine Maria, who got her green card through her son. She went back to her home country to sell her old house, thinking it would take 3 months. But then she got sick. Then her sister needed help, and then she decided to stay for the holidays. 18 months passed. She didn't get a re-entry permit. When she finally flew back to Miami, CBP flagged her. She had no U.S. bank account, Her son paid for everything, no driver's license, and had never filed taxes because she had no income. The officer argued she had abandoned her residence. Maria was pressured to sign Form I-407. If she signs, she is on the next plane home. If she refuses, she gets paroled into the U.S., but has to spend thousands of dollars on a lawyer to convince a judge to let her stay. This is the reality. To avoid being Maria, you must count your days. You must treat the 6-month mark as a soft warning and the 1-year mark as a hard deadline. If you are approaching 5 months abroad, come back now. Do not wait for a wedding. Do not wait for a birthday. Come back to protect your status. Furthermore, we must address the commuter green card status, which is a rare exception applicable only to residents who live in Canada or Mexico and commute daily or seasonally to the U.S. for work. If you fall into this category, you must have your green card officially designated as commuter status, C2, which exempts you from the residency requirement but requires you to prove regular employment. If you try to live in Canada and work in the U.S. with a regular green card, you are committing fraud. Similarly, we must warn the digital nomads, people who work remotely for U.S. companies but live in Bali, Lisbon, or Medellin. You might think you are safe because you have a U.S. paycheck and a U.S. mailing address, but immigration law cares about your physical presence. If you are physically sleeping outside the U.S. for 300 days a year, you are at extreme risk of losing your card, regardless of where your paycheck comes from. The U.S. government wants residents who actually reside. It is also vital to keep your physical green card valid and unexpired, although an expired card does not mean you have lost your status. Status is legal, the card is just proof. It creates massive headaches at the airport. A 10-year unconditional green card that expires does not revoke your residency, but airlines may refuse to board you. If you have a 2-year conditional green card through marriage, and you fail to file Form I-751 to remove conditions before it expires, your status is automatically terminated and you are deportable. This is a crucial distinction. The crackdown we are seeing at airports often starts with a simple document check. An expired card or a damaged card invites the officer to look closer at your travel history, and that is when they find the abandonment issue. Keep your house in order. File your renewals on time. As we look toward the future of immigration enforcement in 2026 and beyond, it is clear that data integration is the future. DHS is moving toward a system where your entry-exit data, your tax data, your social media data, and your employment data are all interconnected. The days of flying under the radar are over. If you are claiming to be a resident, you must live that reality. If you are unable to live in the U.S. permanently right now due to family or work obligations abroad, you need to have a serious conversation with an immigration attorney about whether it is better to surrender the green card voluntarily and switch to a tourist visa or to fight to keep it with a re-entry permit. Voluntarily surrendering it on your own terms, not under pressure at an airport, can sometimes be the smart strategic move, allowing you to visit as a tourist without stress and perhaps reapply for a green card later when you are truly ready to settle. Finally, let's talk about the ultimate solution to all of these travel anxieties: U.S. citizenship. If you are eligible for naturalization, generally 5 years as a resident or 3 years if married to a U.S. citizen, apply now. Do not wait. A U.S. citizen can live abroad for 20 years, pay 0 U.S. taxes, if under the income threshold, and never step foot in America, and they can still walk through that border with a U.S. passport and cannot be denied entry. Citizenship is the only true permanent status. If you are holding on to a green card because you are afraid of the English test or the civics test, I urge you to reconsider. The risk of holding a green card in this enforcement era is high, and the security of a U.S. passport is priceless. Until you become a citizen, you are a guest, and guests can be asked to leave. In conclusion, the Department of Homeland Security's current posture at airports is aggressive, data-driven, and unforgiving. They are filtering for residents who have let their ties to America slip, and they are using the concept of abandonment to strip residency from thousands of people. You have the power to protect yourself, but only if you take action before you arrive at the airport. Maintain your home, file your taxes, watch your dates, get a re-entry permit if necessary, and never ever sign Form I-407 if you want to stay in America. This is a wake-up call for the entire immigrant community to stop treating residency casually and start treating it like the precious, fragile legal status that it is. If you found this deep dive warning helpful and you want to stay one step ahead of DHS enforcement, please like this video and subscribe to U.S. Immigration Insight right now. We post daily updates that cut through the noise and give you the legal strategies you need to survive. Share this video with your friends, your family, and your community groups. Many people are completely walking blind into this trap. Stay informed, keep your documents ready, protect your American dream, and safe travels. Thank you for watching U.S. Immigration Insight.